to the fourth and final program in this lawyer series of Beth Sholem. I wanted to thank the cantor and the rabbi of Beth Sholem. It was their idea for this program, and hopefully we'll do something like this again. If you have or if you have an evaluation, please do send them John Rosen. Welcome back, John.
Thank you.
And tonight, the questions aren't going to be mine. You're welcome. The questions are going to be our members' questions, and hopefully we can get through all of them. There are a number of them, and please, if you have questions as the program proceeds, you're welcome to include them, and if I have time, I'll certainly ask John, all right? So, John, we're going to start with a softball question, which it deals with balance of life as a criminal lawyer. And here's the question. How do you cope with a long trial taking you away from the office and home for weeks or months at a time? How do you maintain the rest of the client files in your practice and your family life? Obviously, it's divorced from the present situation with the COVID pandemic, but generally that's a very, very important question. How do you do that, John?
Well, you should ask my wife, actually, because she's put up with it for 50 years. But the reality is that if I didn't have somebody at home to manage my personal life, I'd have been a disaster. And that's all there is to it. You do what you have to do. My wife bought into the plan before we got married, and she and I have been a team ever since. And Hannah and I, she looks after all the personal stuff. I look after the practice, and it works.
What about, John, the other part of the question, which is you're in a case that perhaps goes on for a month or 2 months, and you have other clients, and
right?
They need your attention. So how do you address that issue?
Well, the interesting thing about criminal law is that once you get past the intake and the file is progressing, everything slows down and you're calendar driven. So when you block out a certain amount of time to do a trial, you know that except for people getting arrested or having issues during, blowing their bail or whatever, you don't have to worry about the next case until you get to the end of this one. And I've been fortunate to always have associates who can cover me in case of emergencies. As a matter of fact, I'd rather do long trials than one little trial after another. It's easier to do.
John, something very dramatic happened last week. I think the first time in the country's history. The government appointed 9 women judges last week. No men, 9 women.
Right.
And the question, when you started practicing law a number of years ago, were all the judges men? And what was that like?
There were a few women who had been appointed in the 60s and early 70s. Well, when I started practicing, there were a couple of women who had been appointed to what was then the county court. And I think there was 1 or 2 in what used to be the Supreme Court of Ontario, the Superior Court. I don't think there were any on the Court of Appeal, and I don't think there were any at the Supreme Court of Canada.
Was June Bernhardt the first woman in provincial court? At least that's my memory.
I thought there was someone before. She may have been. Mabel Van
Camp.
Van Camp. I think she was the first Superior Court judge to be appointed in Ontario. When I first started practicing in 1970, I used to go out of Toronto to do trials. And some of the older courthouses were not equipped to deal with women. So the women who showed up to do cases and had to change either came fully gowned in their car, which was frowned on at the time, or they had to go into the ladies' public washroom to change. And that's the way it was. It was unfortunate, it wasn't fair, and a lot of people felt that way. And it just took time for the bar to accommodate. I remember being in court in my first year of practice, and there were a number of people there, a number of cases, and a woman came up to actually testify as a witness, and she was wearing a pantsuit, which of course was stylish in the early 1970s, with the flared cuffs and everything. And the judge says, "Madam, I can't hear you. Please go home and change into a dress." Oh boy, you can imagine that happening today.
Yeah, well, that judge might not
Times
be
have
a judge.
changed. Times have changed.
Yes, they have changed, John. But let's focus more on the point of the difference. Is it really just the same, or do you see some differences with a diversified bench? We can include not just sex, but also people of color. The judiciary's changed over the years. Is that different or just the same as when you started?
Well, it's a human system. Look, when I first started, when I went out for my first articling interview, 2 minutes into the interview, the man who was interviewing me asked me where else I had been to interview. And I said, "You're the first." And he said, "Well, you wouldn't be comfortable here. Why don't you go to Goodman and Goodman or Goodman and Carr or Rosenfeld, Schwartz and Brown?" That was 1970. And let me tell you, it wasn't any better in the courtroom. So things change. It's a human system. We're all just passing through, and things do change, and hopefully for the better. And now we have more than 50% women at the bar, so it's only fair that there should be more than 50% women judges. I think that's the correct thing.
Yeah. John, the next question is, how do you as a trial lawyer for accused criminals reconcile advocating for their innocence, despite that they may very well be guilty of what they're accused of?
Well, I think the emphasis should be on accused, not criminal. The reason is that people I represent have a problem. They've been accused of a crime, and doesn't matter who they are. It doesn't matter whether they come from a pristine background or have a long criminal record. They have to be treated the same by the courts, no matter who they are. And my job is to resolve their issue as best I can within the boundaries of the rules and the laws I know it to be. So I don't have a problem with it. I'm not the decider. I don't decide what happens to them. I don't decide whether they're guilty or not guilty. And if they're guilty, I don't decide what the sentence is. I'm just their voice to say the things and do the things that they would do if they'd gone to law school and practiced.
John, what type of defendant is the hardest to advocate for, and how do you separate yourself emotionally from your position?
Actually, the client that is the worst to deal with is the client who comes with an agenda, who thinks he or she knows better than the lawyer, who is not prepared to be educated about the system, who has a worldview that just won't change in terms of how things are done, and is impatient. I can't take that, and I've often fired clients because I just can't get along with people like that.
John, by agenda, do you mean the defense that to be offered, or the type of questions?
Sometimes they come with a chip on their shoulder. They come thinking that they're the victim. They can't accept what's happened. I remember acting for a police officer on the charge of sexual assault, and the very first day we appeared in court, he went over to the prosecutor to introduce himself and say, you're on my side too, aren't you? And the prosecutor had to come over to me and say, "Please keep him away from me." I mean, anyways, he turned out to be a very good client after that, because I read him the Riot Act and he bought into the plan.
All right. John, the U.S. Justice system is being in the news this week. A couple of major cases, one of police brutality. So here's the question. What are the major differences between the Canadian and U.S. criminal justice system? Is one system superior to the other?
Okay, so first of all, what the police do on the street, although they are part of the criminal justice system, is just the tip of the iceberg in terms of the system. The system really consists of the investigations, the collection of evidence, the process by which it's presented at a fair trial, and the ultimate decision by either a judge alone or judge and jury. So if you look at the entire system, in my humble opinion, and others will disagree, I believe that we have a much better system than the Americans do. And that's because we have maintained the British traditions and have not discarded them. We also have not become a patchwork of practices as the 52 states of the Union have. And so there is a consistency across Canada, both in terms of practice and procedure, but also in terms of ethical standards, professionalism, collegiality of the bar, and the understanding that although it's an adversarial system, everybody who works within it does so in a civilized manner. And I think that's the difference. We also don't spend our time arguing our case in the press. We argue it in the courtroom.
Right.
There's your
what are the differences? Sorry, John, did I interrupt you?
No, I was just going to say, there's your lead into the next question.
One of the differences between the system leads to another question, which is about court delay. When I covered the Conrad Black trial, remember he went from the indictment, a very complex indictment, to trial within a course of a year. And of course, that wouldn't be the case typically in a Canadian fraud trial. It would take years.
Well,
let me just ask the question. Court delays cause people to lose confidence in the system. Any suggestions as to how to streamline or fix the system?
Well, I certainly wouldn't streamline it the way the Americans have. They have different rules with respect to disclosure. They hold things back. It's a very, very dirty system. A lot of wrongful convictions occur there, more so than in Canada. Not that we haven't had our share, but they do. In order for the way our system works, is designed to work, is to stop everything, just calm down, and let's deal with it in a thorough but civil manner. Put all the emotion aside, and let's just deal with each case properly. There isn't a rush to justice. There aren't limitations on prosecutors as to how long they can examine the complainant. There aren't limitations on the defense as to how long they can cross-examine the complainant. We just take our time, one case at a time. So how do we speed things up? Well, the first thing you do is you get rid of all the junky cases, charges that shouldn't be there in the first place, charges that have been laid too high that really should be resolved at a lower level, and get rid of the number of people coming in through the triage system and beyond. That will then give us more time. The other thing is there should be better coordination. I mean, there's a lot of coordination now, but there should be better coordination among the police, the crowns, and the defense to get the cases ready to go to trial on a much more cooperative basis. And then you also have to have the judges become a little bit more active than they are in terms of pushing things along. Those are the three things that I would do.
By judges pushing things along, you mean forcing lawyers to set earlier dates and prosecutors to get the evidence together? Is that why?
No, more like administrative judges, not the trial judge, but the administrative judges should be much more hands-on in terms of narrowing the issues and pushing the prosecutors to make proper disclosure or complete disclosure, pressing both sides to resolve if a resolution is reasonable, and if not, and if it's going to go to trial, to be much more proactive in getting admissions and streamlining the trial. Everybody has to be thinking about what the trial is going to be like. And sometimes that doesn't happen. Sometimes the pretrial judges just take a pro forma approach, say, well, it can't be resolved, it's going to trial, good luck and goodbye, you know. And that's unfortunate. The judges are getting better at it, I should say, but.
Sorry, John, I didn't mean to interrupt.
No, but you're not interrupting.
All right. You referred to that we have the point that we have a better system of disclosure. I'm not really sure that our audience appreciates the importance of what really disclosure means.
Right.
What is disclosure?
Well, as you know, Steve, under our Constitution, the Supreme Court of Canada has said that in order to guarantee a fair trial, the accused should be told in advance about all of the evidence that was collected during the course of the investigation, at least the relevant or reasonably relevant, and certainly not irrelevant evidence collected. And the reason for that is because public funds have been used to finance the investigation. The fruits of the investigation don't belong to the police or the Crown, they belong to the public. And the accused is part of the public and one of the parties that goes into the courtroom. And to make the trial fair, the accused should have access to exactly the same information that the prosecution has. In the United States, that's not the case. And it's much more cutthroat, and they hold back things and things come out later. And as I said, there's often miscarriages of justice. And in the United States, that can be lethal. They execute people all the time who are innocent.
Okay, thank you, John. In the Bernardo case, you had media attention from across Canada, the United States, and even internationally. Many of your cases are high profile. How do you handle that type of media scrutiny?
Well, the first thing I do, other people handle it differently, but the first thing I do is I remember that my job is not to interface with the media. My job is to appear as counsel at trial. However, early on in my career, probably my second murder case, one of the court reporters in the days when there used to be court reporters in the courthouses who would regularly report on cases, after I had won a trial, my second trial, he said to me that the reporters were all outside waiting, and I should think carefully about what I was prepared to say. And remember, he said, they're only going to report the answer, not the question. So don't worry about what the question is. Know what your own speaking points are. And it was advice I never forgot. And it's true. And if you watch the clip on TV or even the blurb in the newspaper, you will see that what is printed or what is televised is the lawyer's answer, not the question. And so if you think about it in those terms, and it has to be a soundbite that they can put in their story and build around, and it has to be a neutral thing. So there is a way to deal with the press. I just treat it as part of the job. I don't get caught up in all the hoopla and all that. It's just another facet of the case that has to be dealt with.
John, you spoke about speaking to the media after the verdict. Would you ever speak to the media during the trial or before the trial starts?
No. So in Bernardo, just as an example, so in Bernardo, when I got involved late, I went down to one of my first court appearances was in St. Catharines, where the case originated. And when I pulled into the parking lot, which was about 2 blocks away from the courthouse, about 30 reporters and cameramen and everything, they scrummed me right at my car. And I was not a happy camper. And I knew of some of them as well. So I didn't say anything, and I walked and they followed me, and I got into the courthouse where they can't come except like the cameras can't come. And I said to them, I gathered them together and I said, okay, we're off the record. Yes. I said, okay, don't ever scrum me again, ever. I said, I understand you have a job to do. I will cooperate with you if you cooperate with me. I will explain things to you off the record about what's going on in court if you don't understand. So feel free to ask me questions, but it's always off the record. When I come to court, I will let you know I'm coming. And you can set up your cameras near the courthouse, and you can even ask me questions, which I won't answer, but at least you'll have something to report. And so for 6 months, I would pull it, when they moved it to Toronto, I would drive downtown, I would pull into the parking lot, I would honk the horn so they knew I was there. I'd pull into the parking lot, get myself organized, and I'd walk that path towards the courtroom door, and they'd take pictures and they'd ask me questions, and I wouldn't answer anything, and I'd walk in. That's how you handle it.
Couldn't be a more stark contrast to the OJ trial that was happening around the time you at least were retained on the case, where the lawyers would run outside, not waiting for the scrum, create the scrum and give comments about what happened each day in the courtroom. So that's another difference between their two systems.
Well, how about what's going on in Georgia? The lawyer for the guy who was taking the film said, my client didn't do anything. He was just following. He's arguing his case in court, in the public eye. And who knows what the evidence will be and how it's all going to play out. I would never do that. I think you hurt the client more than help them.
Yeah. Well, I had spoken to you before we started about a Netflix series called Trial by Media, and the third segment is about a former governor, Rod Blagojevich, and he started this whole profile of creating a defense in the media, and it completely backfired, and it's exposed.
Absolutely.
Never works. John, how do you leave the horror of society's worst offenders at the office and not let it affect you personally? You're such a happy-go-lucky, warm human being. So the question is legit.
Not in court, am I?
No.
But it's a hard question to answer because, and maybe it's in my DNA, I don't know, but I'm able to compartmentalize things and not take it home. I would think that a doctor working in the emergency room of any hospital might be in a very similar position where when they're on the job, they're on the job, and when they leave, they try not to take it home with them. And I think that's the same thing.
But I bet what would be fair is what you do take home is risking an injustice, the not letting an innocent person.
Yeah. Absolutely. That's where the focus is. That's the sleepless nights and the late hours and everything, is to make sure that I'm doing my job properly and I haven't left a stone unturned that is going to impact negatively on my client. That's the focus.
We have a couple of questions about plea bargaining or plea negotiations or plea discussions. It has various terms. So the question is, do you ever plea bargain for your clients in a murder case? How often is plea bargaining used for expediency versus being needed in order to obtain evidence for criminal prosecution?
Well, in the first place, plea bargaining is a sort of a pejorative term. It has a nasty connotation. It sounds like you're trading bodies, and that's very unfair. Anybody who's been involved in the justice system, whether it's civil, criminal, family, the commercial court, bankruptcies, it doesn't matter, knows that litigation is expensive, both in terms of time, money, and sometimes results, and that reasonable people can come to reasonable accommodation, arrive at a point where everybody can live with the result. In most cases. Now, in some cases, you can't do that and it has to go to trial. But in most cases, everybody can do that. So the prosecution, the entire system would collapse if counsel didn't discuss the resolution of charges, whether it's a guilty plea, but we'll talk about the sentence, or it's a guilty plea, but we'll talk about what the facts are and the sentence because that will impact on parole. Or, look, I didn't commit that offense, but I committed a lesser offense, and what's the appropriate penalty, and other things. Or things like, I will assist you in your prosecution of the real bad guy if you give me a break, whatever, okay? And most of the time that works. It doesn't always. I mean, there are mistakes that are made, Karla, Homolka'z, for example. But having said that, that's the way the system is. And we call it plea resolution or plea discussions. It's not a bargain. It is a negotiation, a discussion, a frank discussion about the case from both sides to see if you can come up with a resolution that doesn't require the cost of a trial. That's what you're trying to avoid, and the inconvenience to the witnesses.
In other words, it's not expediency, it's done with integrity. Really, that's the point you're making.
Absolutely, absolutely.
Sean, here's a question about the Homolka'z case. What are your thoughts about the evidence that was withheld and came up after Karla Homolka'z guilty plea, showing her to be less than an accompanying victim? And of course, that's the videotapes.
Well, that is that's a question that makes some assumptions that aren't correct. So
please tell us what those assumptions are.
Yeah, so let's see, how do you do this? So the police had two victims, one from St. Catharines that was dumped in Burlington, one from Burlington that was chopped up and put into the reservoir in St. Catharines. So they didn't know what the heck was going on. In the meantime, the police in Toronto, in the early days of DNA, had finally gotten a result with respect to DNA that may link Bernardo to the sex assaults that were allegedly perpetrated by the Scarborough rapist. So he became a person of interest, and it wasn't a 100% hit, but it was enough to further their investigation. So they went down to Niagara, and doing what police always do, they don't go right to the target. They go peripherally. So they found out that he was separated from his wife. And they figured that a separated wife might have a lot to say about him that would further their investigation. So they went to see her. And she got scared because she was involved. She didn't say that. So she, instead of sitting down and cooperating, she went and got a lawyer. And the lawyer, she told the lawyer what her involvement was. And she did tell the lawyer that there were these tapes. So the lawyer went and saw the local Crown attorney in St. Catharines and said, what if I have a client who's prepared to cooperate and tell you everything truthfully? What can you do in return? And at that time, the police did not know anything about tapes. They didn't know anything about her involvement. They knew nothing about the case. And they were, no, but this is the point. They worked it out, and she sat down and she told them virtually everything that happened. Did she minimize her role? Absolutely, but she told them, including the tapes. And They took that part of that house apart and never found the tapes.
You told them where
when they did the guilty plea for her, they didn't have the tapes. So don't say that it came after the guilty plea. They didn't have them to assess. It wasn't until after they had given up on the search that the other defense counsel that I replaced went in and took them, and they wound up ultimately in my possession. I gave them to the authorities, but by that time she had been dealt with. So you see, It's not as simple a question as you think it is.
Right, and there was a public inquiry which basically confirmed exactly what you're saying, the Galligan inquiry.
Right, in terms of her and also the failings of the police and so forth. That's right.
John, when the tapes were played in the courtroom, and we should emphasize these were crimes, but not the actual murders themselves, the tapes. The prosecution wanted to have the courtroom cleared of the public when the videotapes were played. You objected. Why did you object to that? Why did you want the public in the courtroom? This is my question.
Well, the impetus for the request came not from the prosecution. Well, it officially it did, but in fact, it was the pressure of the families of the victims who didn't want the tapes played in open court. And I do understand their sensitivity, and I understood it at the time. As you know, under the criminal code, courtrooms are open, and everything should be shown that can be shown to the public, so that the public gets a sense of whether or not it's been a fair trial. So I merely stood up and said, you can't clear the courtroom. There's no basis for it in law. And you have to play these tapes in open court for everybody to see. Now, that was the legal side of it. The practical side of it was that I was hoping that the possibility that these tapes would be played in open court might put pressure on the prosecution to come to the bargaining table to see if we could resolve this entire case without a trial. It didn't. So Justice Lesage, in a very Solomon-like way, you know, King Solomon, he decided that the tapes would be played for the jury and all the participants, but the screens would be turned off for the audience. The sound would be played no matter what. The audience could hear the sound, everybody could hear the sound. And they only turned the screen off when a victim was on the screen. The screen was only turned off when the two victims were there. When Karla Homolka'z was on that screen by herself or with Mr. Bernardo, that screen was on. And the message to the jury is, she's no victim, which helped me. So that's what actually happened. The family, spurred on by their counsel, didn't like the ruling. And every time the tapes were going to be played and the screens went off and all that sort of thing, the families stood up en masse at their lawyers' insistence and marched out of court in a big show. And they did it 2 or 3 times. And the jury then sent a note to the trial judge. And the note said, Your Honor, we do not appreciate the family leaving the court whenever the screens are off or whenever the tapes are played. It places undue pressure on us. It makes us feel bad, and it prevents us from doing our job. And we ask you to get them to stop. Now, that's a smart jury.
I would call that the most extraordinary note from a jury, at least that I'm aware.
Oh, I've had others, but that was incredible.
That goes to the Hall of Fame, John. I'm sorry. That's extraordinary. Okay, so this is a very different question from the member. It goes as follows. I feel I have been victimized by a criminal which resulted in losing my money. I want to get my money back. Can I threaten the perpetrator with having him charged with theft, fraud, or other criminal charges in an attempt to force him into returning my money?
Right. Well, the simple answer to that question is no, because the threat of police investigation, the threat of a police investigation or criminal charges is by definition extortion. It is a crime in and of itself. If you were the victim of a crime, the thing to do is to go and see the police, tell them what happened, give your statement, and let them do the investigation. And if they have reasonable grounds to believe that an offense has been committed and that person committed it, they will act and arrest them. But you cannot go and say, if you don't pay me, I'm going to the police, because that's extortion. It's unlawful.
Right. So in other words, John's saying to that particular member, you're going to compound your problems if you follow.
Yeah, you'll be in the same cell as the perpetrator.
Exactly. Maybe with a more severe sentence too.
Yeah.
All right. So here's a very interesting question, John. In the United States, you read about lawyers complaining about judges and their decisions all the time. That never happens in Canada. Why not? Seems like the person's complaining about it.
Well, maybe our judges aren't as crazy as theirs. I don't know, but it's just, you know, they don't give us cause to complain publicly. People have complained, you know. Sometimes they complain too much, you know. Our former colleague Harry Capito said that the Crown and the courts were stuck together like crazy glue and got disbarred. So, I mean, you know, But we don't have that problem. But I found out a long time ago that the culture of the criminal bar in the United States it's so different than ours. It is a three-way war. And the reason I say that, and I can speak to that from personal experiences, I had a client who was about to be extradited to the United States on a fraud charge. And so I went down with him, actually. We got a pass to enter the United States, and we negotiated with the prosecutor that he would testify against the ringleader and get a lenient sentence and so forth. And then we returned, and he pled guilty, and they ordered a pre-sentence report, which we didn't agree with. And so we brought an application to strike out parts of it, and judge just dismissed our application. But at the same time, after we made our submissions, gave him the lowest, there was a range of sentence. He got the lowest end of the range, and then got a further reduction after he testified. Anyways, when we finished in court, I said to the clerk, can I go with the prosecutor to see the judge? She said, why? I said, because I'm from out of the country, never mind out of the state, and I wanted to just pay my respects and thank the court for letting me appear. Wait here. So I waited. A few minutes later, she led us into the judge's chambers, and a clerk came in and sat down with a notepad, ready to take notes. And the judge came in fully dressed and said, what's this about? Like in a very hostile manner. And I said, it's not about anything, Your Honor. I merely wanted to pay my respects as out-of-town counsel and to thank you for allowing me to appear in your court. And that's all it was. It was like somebody had popped a balloon and just everything deflated. He was very nice after that. And I walked out and I said to the local agent that I had hired, what was that all about? He says, that's the culture of the United States bar. The judges don't trust the prosecutors. They don't trust the defense. The defense doesn't trust the judge, doesn't trust the prosecutor. The prosecutor doesn't trust the defense or the judge. It's a three-way war, no matter where you go. And that's the problem.
I was thinking about a case out of Alberta and a sexual assault case where the judge made some fairly egregious comments about the complainant. They're so egregious, I'm not even going to repeat what he said about her conduct, and suggested that because of the way
she couldn't keep her legs closed and all that sort of thing. Right. Yeah.
And so, but the lawyer didn't go out to the media and do a press conference. The lawyer, first of all, appealed successfully, and secondly, took the matter.
The Crown appealed. The Crown appealed.
Right, you're right.
Right.
So the Crown appealed, but the matter was taken to the Judicial Council, and that judge is no longer a judge any longer.
Right.
So there is.
I think he ultimately retired before they fired him. But the point is that, and I understand where you're going with this, Steve. Yes, judges, look, they're human. Some of them do the most ridiculous, stupid thing possible. And when they do it on the bench and they do it in public, they too are accountable. The system is built on accountability. No one is above the law, not even President Trump. But the point is that even judges are accountable for their conduct, and lawyers certainly
are. So I just have a question about what your thoughts are on Judge Sullivan. That's the judge in the Michael Flynn case. I don't know if you have any thoughts about that, but he's a judge.
Sure.
Okay, go ahead then.
No, I think Judge Sullivan is right on the money. He has an accused who has pled guilty, who has publicly acknowledged committing a crime.
Michael Flynn.
Michael Flynn, and who now wants, and who has not applied himself to withdraw the plea. Rather, the prosecutor has come to court to ask that the plea be struck and the charge withdrawn. Now, in Canada, the prosecution has the right to walk in and withdraw a charge at any time without any hearing, because it's a political act that if you don't like it, go to the polls and vote the next government in. But once the guilty plea is in, I don't think in Canada, it's never been tested, but I don't think they can just walk in and withdraw the charge. They could stay the proceedings, which is different,
Right.
but they can't withdraw the charge. Staying the proceedings means that the proceedings stop and not to be reinstituted until the prosecution decides to. So it could be forever. And again, the entry of a stay is a political act, and it's not a judicial act. But in the United States, their law is a little bit different, or it's very unclear, obviously. And so this judge has the prosecution saying, we want to withdraw the charge, strike the plea. The defense is saying, we agree, and there's nobody on the other side to speak to the opposite. So the judge, in his wisdom, said, I'm going to hire an outside counsel to have an amicus curiae, a friend of the court brief, to give me the other side of the argument so I can make a judicial determination after I hear both sides. And if I'm wrong, the Federal Court of Appeal and the Supreme Court of the United States can look at the record and decide who was right and who was wrong, because that's where it's going. So instead, the defendant, with the Attorney General, ran to the Federal Court of Appeal, a panel of 3, who ordered, very unusual, ordered this judge to get on with the withdrawal by June the 1st, without hearing the argument or anything. And I think this judge is going to say, too bad, what are you going to do to me? Fire me? And I think he's going to proceed the way he wanted to. And I think as well, the amicus briefs that have been filed, they're going to appeal to the full federal court against the panel of 3 to argue about what the law is regarding withdrawal of charges. And that decision is going to go to the Supreme Court of Canada. So the bottom line is the whole system there is in chaos because of William Barr and the way he's running the Attorney General's office. Right.
I just want to encourage anyone who has a question to please send it, because we will have time to address them, all right? Okay, so here's a multi-tiered question, John. How is your relationship with 1, the police, 2, the Crown's office, the prosecutors, and 3, the judiciary changed over the years? Has the level of civility improved, stayed the same, or degenerated?
Well, I can't speak for other people. I can say that in my experience, any conflict that occurred in the early days of my career were my fault, out of inexperience, and over the years, as you practice, you come to appreciate the role that other people play in the system and the pressures that are on them and how they think and who they report to and how the whole system works. And the more you are considerate of that process, the more civil your own conduct becomes, and in return, you gain enormous respect and civility from the others who are involved. And so I never really had any major blow up. I had one police officer who, for some reason, had this vendetta with me. I don't even know why. I mean, my client was acquitted, so maybe that's why. But he was a little off anyways. You know, he was with the old hold-up squad, and what can I tell you? But generally speaking, I don't have a problem. And as a matter of fact, I get a lot of positive feedback from the police, a lot of cooperation, from Crown Counsel, and the judges certainly know that if I say it's a 3-week trial, it's a 3-week trial. I'm not going off half-cocked. If I give my word that we're going to do things a certain way, or we're going to, agree to certain things, that's the way it is, and we get on with it. And they know that I'm in the business of getting the trial done and expediently and efficiently, and then moving on to the next case. And so,
Sorry, John.
so I think that's the way counsel has to act. But Maybe not everybody does it. I don't know, because I don't see.
Have you encountered prosecutors over the course of your career as view you as someone who they want to beat because it's a notch on their belt, on his or her belt?
Oh, I think it's a human system. It wouldn't surprise me. I'm sure it's happened a lot. Certainly, like I said, it's just human nature. But I don't think about it at all. And if I lose, I lose, and I do the best I can, and I move on to the next case and let the appellate lawyer who takes over worry about the record. It's not personal.
So someone just sent a question by Zoom. I only could read part of it, but essentially the question was, if someone has admitted their guilt to you as a lawyer, how do you, in good conscience, or how do you then still proceed to trial if they've told you they're guilty?
Well, it depends what you mean by guilt. So when I first meet a client, I do this little simple diagram for them so they understand where I'm coming from. And I build a little hill. And I put the client at the top of the hill, like that. And I usually draw it with a smiley face and whatever. And I say, look, you're right now at the top of a mountain. Now, if we go down this side, it means I didn't do it. I'm completely innocent. And your defenses are, they can't prove it, lack of identity, I have an alibi, or some combination of that. Said if you're at the other side and it goes down this side, your evidence is, it was me, but I have excuses. I can explain what happened. I was drunk, I was crazy, it wasn't fraud, everything I said was honest. Whatever it is, you're a material witness to the event. The other one, you weren't even around. So if a client comes to me and says, I participated in the event, but when we go into court, I want you to put forward this alibi, and I know the alibi to be false, I refuse. If, on the other hand, the client says, I didn't do it, and here's my alibi, and I check it out, and it turns out to be a phony alibi, I confront the client, and I say, it's a phony alibi. You want to tell me the truth, or do you want to get another lawyer? Because I'm not putting a phony alibi in front of the court. So I have to be guided by my own sense of professionalism and ethics in dealing with my client. I'm not just a mouthpiece. I'm there to solve their problem, but in an ethical way. That's how I handle it. So if a client says, look, Mr. Rosen, I actually did kill the deceased, but I didn't mean to do it, that might be a manslaughter. Or I was drunk at the time, I don't remember what happened, again, a manslaughter. Or I was just bouncing off the walls because I'm paranoid schizophrenic and I think there's little green men that are in my head. Then there's section 16. So it's a difficult question to ask because you have to look at the context of each case.
Right, could be an issue of provocation in a murder case.
Could be provocation, exactly.
Here's the question, John. I'm going to read it carefully. Remember, it's not my question. Understanding you represent the law, and the law was in block letters, and are there to make sure a defendant gets a fair trial, not necessarily go free. How do you mentally prepare yourself to work with someone like Paul Bernardo?
Well, as I've said before, he was a good client because he didn't come with an agenda. He just said, here's my problem. What's the best you can do for me? It's like you go to see a doctor and the doctor says, I'm sorry, you have brain cancer. And you say, well, what can you do for me? Well, we're going to try and do surgery. We're going to try and do chemo. We're going to try and keep you alive. But it might not work. So, tell me what happened. Let's create a defense. Let's go forward. Let's put a factual scenario that is true according to you. And the factual scenario was Karla actually did the killings. If I'm involved as a party. I didn't have the requisite intent to either participate in a first-degree murder or, for that matter, a murder. At most, my liability is manslaughter. Jury didn't buy it. That's not the issue. The issue is that factually it was available. and it was put to the jury to consider. So that's my job. So I don't have a problem with that. I don't have a problem with any client that comes to me and says, here's my problem. You tell me what your best solution is that you see for me. And it may be, look, you are in big trouble here, and the best solution for you is to plead guilty, but we'll work on the sentencing. We'll mitigate the sentence. That might be the resolution. It depends on the case and the client. So I don't have a problem with anybody. I'm not there to represent the law. I'm there to solve the problem of the client within the parameters of the law and the rules of evidence and the procedures that we have to follow, and my ethical obligations.
So John, I'm
Is this too serious for everybody? I mean,
no, it's not serious at all. I mean, these are serious questions, but
yeah, they are, but I feel like, you know, go ahead.
no, but these are the questions that were asked. So clearly people take it very seriously.
Yeah, I know, no, clearly, I know, yeah.
Yeah. I did ask Brian this question. Have you ever used humor in the courtroom? Do you find humor works as a tool of advocacy?
No. I mean, humor works when you're the object of the joke. When you try to make someone else the object of the joke, juries think that you're beating up on them. And so I remember a mutual friend of ours who, there were 3 Vietnamese guys charged with first-degree murder. And the 2 of them were ethnic Chinese. And all of the other guys, there was 2 gangs, the other guys who came to testify all had nicknames. And one guy's name was Afuk, so you can see where this is going. And he cross-examines this witness. And at the end of it says, so sir, all we're left with, as far as your evidence goes, is Afuk. And he thought that was very funny, and he sat down. So the judge got all upset and excused the jury, and he was going to give him hell. And before he could say anything, a note came from the jury. And the note said, we think Mr. So-and-so was grossly unfair to the witness and owes him an apology.
Yeah.
And the judge says, I don't have to say anything.
I don't have to say anything.
You know, like, and that lawyer groveled for the rest of the trial. And I was so angry because I thought it was going to sort of splash back on my client, and that we were all going to go down like lead sinkers hooked together. As a matter of fact, at the end of the day, that jury that sent that note found all 3 accused not guilty.
Really? Yeah, well, that lawyer was really...
So don't be a smartass in court, and don't, and you know,
But
yes.
are there ways to level the tension? I mean, you have so much tension in these, particularly these murder cases. Do you have devices that you rely on? If not humor, something else, or is it just...
No, humor, you know, at the appropriate time, and, you know, it's a human system, and yeah, there are little asides. It's like being on stage. I'm sure actors on stage whisper things to each other, or wink or nod or whatever, but you know, I find that I spend more time focusing on the jury and trying to create a rapport with the jury through facial expressions and modulations in my voice, and I watch their eyes to see whether they are still interested in what I have to say. If they're not, I'm in trouble.
John, we just received a very nice message from Abe Lewinsky, who's the president of Beth Shalom.
Hey.
Thanking you for your participation, and obviously Brian Greenspan as well, and called it a fabulous program. So I wanted to mention that. And this is the penultimate question. It's mine. And I did ask it as the last question to Brian too. So I'm going to refer to one of the great criminal lawyers in the United States, Albert Krieger. He was John Gotti's lawyer, just one of his many famous clients. And this great American defense lawyer who just died in the last couple of weeks gave a speech in 2008 where he said the criminal defense lawyer marches into the pit, often unloved by everyone in the courtroom. And I think that's quite true. It may be unloved by everyone in the courtroom. I don't even know if you'd qualify it. So my question for you, John, is, okay, so you walk into a courtroom like Bernardo or any other case, you're unloved by everyone, particularly the triers of fact, the jurors. How do you turn that around? How do you get them to like you and respect you?
Right. Well, okay. In order to understand this, you have to understand human nature. So I don't know how many people who are on the call have ever been on a jury or not, but when the trial starts, the jury panel is brought into the courtroom before the judge even walks in, and then you walk in. Sometimes you walk in with your client, or they bring the client in, whatever. And I always tell clients that from that moment in time, the client and I are center stage, and everything we say and everything we do and every way we act is going to impact on the people who will be on the jury, starting with the jury panel of 250 people. And then we go through the process. And as we proceed to select the jury, we don't have questioning like they do in the United States, but everything we do, every interaction with the judge, every interaction with the jurors, even to the point of looking a juror in the eye and saying, content, I'm content with this juror, begins the process of making a human connection to the people that are going to try the case. And even if in a judge alone case, when you come in, you begin by looking the judge directly in the eye and starting that sort of subtle communication that goes on beyond verbal communication. So that's the beginning, and you set the stage. Now, jurors, at the beginning, they don't know who's who. They don't really understand. Maybe they think that's the bad guy. Maybe they think that guy's guilty. Most of them, though, want to hear the story. They may come in with preconceived ideas, but I would say 99% of jurors want to hear what happened. So the way you connect to the jury, and even for that matter, to the judge, is slowly and methodically with each witness. That's the Crown calls. You don't just cross-examine them for the sake of cross-examining them and say everybody's a liar. No, you listen to what they have to say. You live with most of what they say. If you have to attack something they say, then you do that. But a lot of times I spend my time refining what the jury says and turning it so that it is seen in a different light, favorable to my client. And it's like building blocks, one witness at a time. And as you do that, and if you're doing it correctly, the jury, who starts to mentally see the picture that you're painting, comes to understand what you're trying to do and starts to move along with you. And so all of the preconceived ideas are left at the door. All of the sort of the pre-publicity hatred and prejudice and all that, 12 people in the jury, they forget about all that. They're skeptical, but once you get into it, assuming you have something to say and assuming you have a defense, all of that is left away. And at the end of the day, if you've done your job, you're going to get the result that you want. Not necessarily a full acquittal, sometimes an acquittal of the main charge, but maybe guilty of some smaller charge. It depends on what your goal is. That's how you do it. That's to answer that question. That's what happens. These are not compartmentalized questions. You have to understand the whole process that you get involved in, I think.
John, do jurors ever come back to you after trial, win or lose, just to talk to you, shake your hand, schmooze with you, say anything? I know they can't discuss their deliberations, but just a courteous greeting.
Sometimes I've had jurors. I did a fraud case. It was a retrial of a lawyer who had been convicted of fraud, got 4 years. Eddie Greenspan did the appeal, but didn't want to do the retrial because he thought he was guilty. But anyways, and on the retrial, we had a jury. And after a 3-week trial, the jury acquitted the client. And most of them waited at the bottom of the escalator on the main floor of the courthouse for him to come down from the 4th floor so they could shake his hand and my hand and tell him how badly he had been treated by the Crown and police. It was a pretty good win.
Well,
So yeah,
story.
it's a human system. I'm very approachable. So if they want to talk to me, I'm happy. If they don't, then they don't. I understand when they're finished doing their job, they go out the back door. A lot of them, they just want to go home. You know, I've had jurors who come up to me years later on the street and say, "You probably don't remember me, but I was a juror on this and this trial. And yes, we convicted, but you did a great job. Or, yes, we acquitted. And how's your client doing?" You know,
John, do you remember those jurors? Do you remember them?
you know, I most of the time no, because you know it's 12 strangers that you see in a special context, and then you know years later you meet them on the street.
Okay, well, John, in my closing remarks, I first want to say that I kept my word to you. We finished it in exactly 1 hour. So I wanted
Wow.
to thank you. Yeah, I wanted to thank you. And I
I'm
want everyone
available.
to
I
know.
mean, anybody wants to ask a question, you know, I'm happy to answer. But I hope people have found this informative and a little entertaining and a good way to spend part of the COVID isolation. And I hope I've
Well,
helped.
that was the inspiration for the rabbi and the cantor to choose these programs. But I just wanted to say, first of all, I'm quite sure that everyone has found this to be insightful and entertaining. That's number one. Secondly, I just want everyone to know what a treat it is to not just have 2 of the finest criminal lawyers, and I'm not given to gratuitous praise. John knows that.
Wait, who's the
But
other
not
one?
just
Oh, right, Brian.
not 2 of the best criminal lawyers, Brian Greenspan and John Rosen, but 2 of the best criminal lawyers in the history of this country. And so you've been really treated to 2 of the best. And I wanted to thank you, John. I thanked Brian already. Thank you for graciously contributing your time, giving really fabulous answers in both programs. And hopefully we can do something like this again. Thank you all for watching and participating. Great questions. And Erev Tov, everyone have a good night. Take care.
Oh, yes, it's Shavuos tomorrow. Thank you, everyone. And by the way, Stephen, you can't minimize Eddie Greenspan's contribution. He was Eddie. So.
I should tell you, John, in the last question, I was asked by a member to post to Brian his favorite Eddie story. So I gave kudos to Eddie Greenspan. And you know, I said this, and I'll say this again, his and I was in the courtroom in Chicago, as you know, wrote a book about the case. Mm-hmm. But in Conrad Black, because he was disparaged and received a lot of unfair treatment, his cross-examination of David Radler, the accomplice, was one of the finest pieces of advocacy, one of the finest cross-examinations that I've ever seen.
But it means nothing if you perform it in a culture that you know nothing about and haven't lived in, and that is the problem. So, but besides that, Eddie was an excellent lawyer. So, anyways, thank you, everybody. Out west, I hope things are okay, and we'll speak together.
Thank you.
Thank you, everyone. Okay, good night. Thank you.
Good night.